This conference will now be recorded.
So I'd like to welcome everybody who's joining me today, Wednesday, May 24th, 2023, where we're going to talk about everything that family law attorneys need to know when representing a client who's either healthy or who has a disability. So I'd like to start with the intake process because I think that the information we either ask for or forget to ask for is so important and ends up paving the way for how the divorce proceeding can go. And so I'd like to make some suggestions to start that you add some of these items to your intake process if you don't already include them. And the first one is to find out if this potential client has any physical disability, mental disability, emotional disability, or perhaps a medical diagnosis that you should be aware of. Now, why is this important? Well, from my point of view as an elder law attorney, we want to ensure the success of the divorce proceeding. And we want to ensure that the divorce proceeding is able to proceed in a timely way. If you find out that the client has a physical, mental, or emotional disability, then it's probably a good idea to talk with that client at the very beginning about the importance of having a durable power of attorney. That way, if while you're in the middle, let's say, of the discovery process or you're leading up to mediation, something happens and the client is now incapacitated or has diminished capacity, it means you can still proceed. Things are not going to stop as long as they have a well-written, durable power of attorney, giving somebody they trust the ability to continue the litigation on their behalf. So I think disabilities and health are very important, not just for your client, but also ask the same question regarding the other spouse, because that can factor in to how you're going to approach the case. It's also a really important idea to ask about health insurance, because again, if we have somebody who perhaps has a pre-existing condition, health insurance is an issue that should come up during the negotiation process. Today, we're also going to talk about why it's important in the intake process to ask your new clients whether they're receiving or have they applied for any government benefits. We're also going to explain why asking if the child of the marriage has a disability is also important when we're looking at child support and whether that child might need government benefits themselves when they become an adult at age 18. So we're going to start today's discussion talking about how do you work with a client that you think has diminished capacity. Now, the bar recently revised the rule that used to be called client under a disability. And I want to talk a little bit about the importance of the revision to the rules and also provide you with some tips. So now what has changed in the rule is diminished capacity could be a result of many things. It could be a mental health diagnosis. It could be that the client had a car accident, hit their head. Perhaps there is trauma to the brain. It can also mean that you are representing a client who has a very weak will. They're not strong. They're being influenced in a way that's not favorable to them. So what the rule talks about and how it's now different than the prior rule is we as attorneys are allowed to take protective action. So what does that actually mean, practically speaking? Well, it means that we can talk to a family member who maybe needs to be involved in the meetings and the discussion so that we can properly represent the client. It also means asking the client, do they have a power of attorney? Can you speak with the person who is named as the financial decision maker on their behalf as you go through the litigation process? It may also mean that if you suspect that your client is being taken advantage, either financially being exploited, or perhaps they are being abused mentally and emotionally, you may then be allowed, under this definition of protective action, to go ahead and file a petition under the criminal chapter seeking an injunction to protect a vulnerable adult. The rule does tell us that the preference is to seek these methods of protective action before we proceed to file for a guardianship. That should really be the measure of last resort, only after we've exhausted the other remedies. So I do encourage everybody to read how they've revised the rule as well as the commentary to the rule. So what can we offer a client as being an alternative to a guardianship if we're concerned that they might have diminished capacity, or we're not concerned about diminished capacity, but we know that maybe there's a health issue? So there's two very important documents that Florida law offers. The first is the durable power of attorney, which is a way of delegating financial decisions to a trusted adult. And that can include everything that we do and we take for granted. We don't think about it. We talk to our financial advisor. We go into the bank. We pay bills either online or through ACH or by check. We make decisions or changes about our investments. We might need to call up the IRA or the 401k administrator. We also need to be able to sign income tax returns or other kinds of tax documents. So all of these powers are things that can be delegated by a competent adult to another adult. And that could include language to allow an existing lawsuit to proceed forward. Now that will help our clients when it comes to financial decision making, but it's equally important that we help clients address the other side of their lives, which is the healthcare side. So the document we use in Florida is known as the designation of healthcare surrogate. And like the power of attorney, it is a way of delegating medical decisions to a trusted individual. This can be temporary decisions, more permanent long-term decisions. But what's really key about these two documents is when we have them written, and they're written well, they help our clients avoid a guardianship. And we're going to talk a little bit later about what the pros and cons are of guardianship. But the key here is it's going to allow the divorce litigation to proceed without interruption, which is very important. And so if we're not recommending this, that they create what I call an incapacity plan, having these documents in place should incapacity occur or diminished capacity occurs, then unfortunately we're going to find ourselves in a situation where the proceeding is going to slow down, possibly be halted, and then we may be looking at another proceeding in the probate division called a guardianship. So why do I want people to avoid a guardianship? Very simply, number one, it's time consuming. Unless you have a true emergency situation, it's going to take anywhere from 4 to 6 weeks to get through the process, get through the hearing, and get a guardian appointed. So it can be very time consuming. So what are the emergency situations that a court will allow us to come in on basically 24-hour notice? We either need to demonstrate that there is financial exploitation occurring, which means I need to have bank statements, I need to perhaps have a bank officer to testify or a police officer who might be investigating financial exploitation. The other option to establish an emergency is showing the probate judge that this alleged incapacitated person is either being self-neglectful or they are being neglected by a caregiver, meaning that their health, safety, and welfare is in jeopardy. And again, we're going to need witnesses to testify, people who have observed this. Has Adult Protective Services been called out because perhaps a neighbor called the 800 abuse hotline? So absent us being able to demonstrate one of these two emergency situations, getting a guardian appointed is going to take longer than most people want it to take. Now, the second reason we want to consider guardianship as the measure of last resort is it is expensive. Many consumers are going to think that the guardianship is over and they don't need an attorney once the guardian is appointed by the judge. And that is actually incorrect. In Florida, our guardianship law requires that the guardian continue to be represented by an attorney until the ward either passes away or the incapacitated person recovers and they have their rights restored. Those two situations are usually very unlikely to occur, not that they can't, but many times it is not the norm. So it's expensive, not just because in the beginning we have 2 filing fees, and not just because in the beginning we have a 3-person medical examining committee that are each entitled to be paid for their time, but you have the ongoing legal fees for the attorney representing the guardianship. And if a guardianship continues for 2 or 3 decades, and some of mine have, you could be looking at tens of thousands of dollars in legal fees. Whereas if we can educate the client to create the durable power of attorney, the designation of healthcare surrogate, that is a far less expensive approach than the guardianship. And last but not least, in a guardianship, people lose their privacy. Those of us who are watching the webinar today are lawyers. We know that since 2012, the state of Florida is electronic, and that means that the public has the ability to view a lot of the documents that are filed in a guardianship. There are only a few documents that are considered confidential that cannot be viewed, and those would be things like the annual accountings that are filed. So wouldn't we want to help our clients keep their privacy? When they have a power of attorney and a healthcare surrogate, those documents don't get filed with the court and they're not recorded. So unless the client chooses to share them with someone they trust, they're not going to have their privacy revealed. So how does the guardianship, if we need one, relate to a divorce proceeding? Well, if the client does not have that durable power of attorney we talked about, and now they're incapacitated and we have to proceed with a guardianship, Florida Statute 61.052, which dovetails with the guardianship chapter of 744, tells us you're going to have to wait 3 years from the date the individual was adjudicated incapacitated before you can proceed with the divorce litigation. Additionally, with an incapacitated individual who's been adjudicated, you're most likely going to need a guardian ad litem appointed by the court for that person. Now, what do we do if our client currently receives financially sensitive government assistance, or perhaps has a condition, has a diagnosis where down the road you are concerned that they are going to have significant medical needs and they're going to need to obtain financially sensitive government assistance? So we're going to touch on 2 types of government benefits. The first one being supplemental security income. Its acronym is SSI, and we're going to touch on Medicaid. So there are many programs under the umbrella of the Social Security Administration. Some are financially sensitive programs and others are not. SSI happens to be the main program that is financially sensitive, which means that if your client does not have assets of $2,000 or lower and does not have very low income, they're not going to get the SSI, which happens to be a financial support. It can either be a direct deposit, they're really trying to steer away from checks now, or they're starting to put SSI benefits on a debit card. Now, the actual amount of the SSI is really not enough to help a person get through a month of their bills and their obligations. But what's important about the SSI in Florida is when somebody receives at least $1 of SSI, they are automatically approved for Florida Medicaid. They do not need to go to the Department of Children and Families and submit a separate application for Medicaid assistance. And that's really where the true value of the benefits lies. So why is Medicaid important? Medicaid is important if we've got a client who, let's say, is diagnosed with multiple sclerosis, MS, Parkinson's, Lou Gehrig's disease. We know that there's right now very little medical technology available to halt, stop, or even reverse the progression of these chronic illnesses. And they are devastating on the physical body. These people will at some point during the disease process need the highest level of medical care we refer to as skilled nursing care. Medicaid will help to pay the cost of skilled nursing care. So that's why it is so important to know if your client has a diagnosis or medical condition, so that not only can you take this into account when you're determining what to ask for in the assets, what to ask for by way of, let's say, alimony, but you want to help them start to create a plan going forward. How are we going to protect that settlement? How are we going to protect the alimony? Well, we have two options. And which option is best for your client has a lot to do with their age, as well as the amount of money they're looking to preserve in order to qualify for Medicaid down the road. So the first one we're going to talk about is called an under 65 disability trust. That's what it's called in the law. It's easier to refer to it as a first party special needs trust. You might see the abbreviation S&T. We are allowed to use this special needs trust for our clients that are under age 65. So as long as you are settling a divorce action and your client is under 65, this is a great planning tool. Now, it does not matter if later on, let's say they come into more assets, we can still keep this trust. Unfortunately, we just cannot add to it after age 65. So let's walk through, how does this work? Well, it's been the law since 1993, so it's been in existence a very long time. And what the law says is all the agencies are willing to allow people with a disability to put their assets, their resources into a first party special needs trust, as long as somebody other than the client will be the trustee, the person in charge of investing, administering, and making sure that the assets are used for the sole benefit of your client. Sole benefit means that the trustee can't give gifts to other people, let's say in the family. The monies can only be used for the person with a disability. Anything that's going to improve the quality of their life, the quality of their care, is what the monies can be used for. And there's no hard and fast rules about this, so it really needs to be tailored to every individual client's needs. That means perhaps you might have a client who wants to go on vacations. You might have a client that needs advanced medical technology that isn't covered by Medicaid or is still considered experimental. I've had clients who go out of the United States for treatment. And since that's not going to be covered and is not approved by the FDA, we use the special needs trust to pay the travel expenses, to have somebody like a home health aide accompany the person, and to pay for the actual medical treatment. Now, the law does say that when the beneficiary of the trust passes on, if they are receiving Medicaid, Medicaid has a right first to be reimbursed up to the total amount Medicaid has paid. But here's the good news. Medicaid is not paying what you and I might see as the full private pay rate. They're paying the provider a negotiated rate. So the payback to Medicaid is at the negotiated rate level. And if it turns out that the trust beneficiary has benefited from every cent in the trust and there is no money left, then there's nothing to repay Medicaid, and nobody else that is related to the client has an obligation to repay the Medicaid lien on the client's behalf. So my view is this is a win-win on how we increase the longevity of the monies you're successfully able to get for the client in the divorce proceeding and make them eligible for the SSI and Medicaid at the same time. Now, what if we have a client that is either over age 65, so we can't use the first party special needs trust, or perhaps the amount that is recovered for the client may not justify either the legal fees for setting up the special needs trust, or we can't find a professional trustee, a professional fiduciary, to administer the trust. Well, then the option we want to consider is called a pooled trust. And by its name, if you think about a pool of water, it means that multiple individuals who have a disability can pool their resources into this one trust, that the trust is managed by a charity, a 501c3 entity, and it's administered according to the same rules as the first party special needs trust. It's meant to be used for the sole benefit of the trust beneficiary. Anything that's going to improve the person's quality of life, quality of care, is an approved expense to be paid. Now, where there is some deviation has to do with what happens when the trust beneficiary passes on and there may be some monies left in their pool trust account. Well, in Florida, we are very lucky to have a lot of options on pool trusts, at least 10 to 13 pool trusts in the state. Some pool trusts have an arrangement with the Agency for Healthcare, which administers Medicaid, to do the direct payback to Medicaid, like we would in a first party special needs trust. And then there are some that have an arrangement where a percentage goes to Medicaid, a percentage goes to the family, and a percentage goes to a charity. And each of these charitable organizations serve a different charitable purpose, so it's nice to be able to offer to clients the opportunity to find a pool trust that perhaps resonates with them or supports a charitable purpose the client likes. One of the questions I had suggested including in your intake process was to ask your new client if there is either a minor from the marriage or perhaps an adult child who has special needs or a disability. Now, why would we want to ask this? Well, sometimes people won't think it's important to share that information with you, and it's very important when it comes to child support. And how will that child support impact that minor or adult child's entitlement to government benefits? So we just talked about SSI and Medicaid for adults, and the same rules apply to a child who in Florida becomes an adult at age 18. If that child is going to get continuing child support, that could be a problem. That's going to be income both under the SSI rules and the Medicaid rules, and that might cause the child to not be eligible for those benefits. However, if in the family law division we work together and we educate the judge and we ask the judge to include language in the order that directs the payment of the child support either into a special needs trust or a pool trust, and it goes directly there each month, then the Social Security Administration and the Medicaid agency won't count that child support as being either available income, or as it grows, it won't be an available resource. So that's why it's very important that we ask this question during the initial intake process. What do you do if in the process of talking with your new client, they happen to tell you that their child is approaching age 18, maybe they have a mental health diagnosis, or perhaps they have a diagnosis of a developmental disability, or there's something that they feel is going to affect their child's ability to make decisions for themselves. Well, that's when we need to talk about two things. We need to consider asking for extended child support beyond age 18. We might need to have the parent or both parents designated as guardians of this soon-to-be adult child. And if we're going to petition the probate division for a guardianship, we can also, through that division, ask the judge to create a special needs trust to receive the continuing child support that will extend beyond age 18. Now, Florida is very unique. And what I mean by that is we have a separate chapter, it's chapter 393, that is meant to be used for a person who is born with a developmental disability. So this cannot be used if a child was healthy at birth, later on had an accident, maybe now has a brain injury or something else. So examples of a developmental disability under the statute include autism or a diagnosis on the autism spectrum, Down syndrome, cerebral palsy, spina bifida, and intellectual disability. Many, many decades ago, intellectual disability was referred to as either retardation, mental handicap. We've now hopefully removed what's associated with those very negative terms, and we refer to it as intellectual disability. What is very cool about a guardian advocate proceeding, rather than a guardianship for these individuals, is that all their legal rights remain intact. And many parents want their children to be encouraged to attain the highest possible level of independence, of self-sufficiency possible. So many of the parents I work with don't want their children's rights removed, and that would include things like teaching them how to vote, teaching them to make a good choice if they want to marry somebody, being able to travel, being able to hold a job, being able to apply for government benefits. So in the guardian advocate proceeding, the judge is making a finding that this now adult child has a developmental disability but needs assistance from the parents to make financial and or medical decisions. And I do suggest to parents that they designate a standby guardian or standby guardian advocate, just as that plan B in case the parent unexpectedly has a car accident and dies, or is so incapacitated that they can no longer serve as the guardian or serve as the guardian advocate. So keep this in your toolbox. This might come up one day, and hopefully you're going to find it helpful. So we've been talking a lot about what's important leading into the divorce, going through the divorce process, and we don't want to forget the importance of life after divorce. What do we need to be telling our clients? Well, to me, one of the most important things is letting the client know that once that order approving the dissolution and the final judgment are entered. Under Florida law, if the client already has, let's say, a will that names the ex-spouse as first beneficiary, the law says we're going to treat that ex-spouse as if they're predeceased. They will no longer inherit. And that same rule of law applies if your client has a durable power of attorney, naming their ex-spouse as their first financial decision maker, and if they have the ex-spouse as their first medical decision maker. But we still want to encourage the clients to make new documents, make a new plan. Why? Well, because in the old plan, if that ex-spouse was named first, they may only have one alternate named, and now technically that alternate becomes the primary, and the client has no alternate plan to fall back on. So I do encourage all of you to talk with your clients about the importance of creating a new legal plan. What Florida law does not cover, and sometimes this comes as a shock to our clients, is it has no impact on beneficiary designations for retirement accounts. Those would include IRAs and 401ks. And there is a case going back to 2009 that I found called Kennedy versus DuPont, where the ex-wife was named on the husband's 401k account. He never changed the beneficiary. Even after he remarried, he forgot to change the beneficiary. And lo and behold, he passes on, and the new wife finds out she is not inheriting that. It's going directly to the ex-spouse. So these are surprises we don't want our clients going through. We want to give them a checklist, tell them here's what you need to do now that the final judgment has been entered. What's also important to counsel our clients about, especially if they have young children under age 18, is to have what is called a declaration of pre-need guardian for a minor. It's a way of saying if I, as the parent, become incapacitated and I'm not going to be able to make decisions like where my child goes to school, giving informed medical consent, things like that, I can choose who would be the guardian for my child. Now, technically, the ex-spouse has priority, especially when it comes to medical decisions. But if there's finances involved, the parent can designate somebody other than the other parent to be guardian of property. So this is an important tool to talk about with our clients. And don't forget that it's important to explain to clients the pros and cons of, let's say, they add a sibling's name onto their account through joint ownership, rather than making a well-written durable power of attorney. Many people are looking for what is the quickest and easiest way to resolve an issue. And usually they will say, oh, I'll just add my friend's name. I'll add my sister or my brother's name onto my account. So if I get sick, they can write checks, they can pay bills. The problem with that logic is that when adding somebody on as a joint owner, you are treating them as the owner of at least a half, if not more, of the value of that asset. So you are potentially subjecting that asset to losses should the joint owner have any kind of financial problems. That could be filing a bankruptcy, or the friend or the sibling filing for divorce themselves. Now that's what we would call an unintended result, but nonetheless, it's going to be the result. Whereas if the client makes a durable power of attorney, that person has permission, not ownership, to handle the assets for their friend when the friend is incapacitated. Now, hopefully everybody is familiar with the two United States Supreme court cases that were decided a few years ago. The first one being the Windsor case, and the second one being the Obergefell case. Both together achieved major strides in our country for treating married same-sex couples as we do the same for heterosexual couples. And so everything that I've talked about today is going to apply to same-sex married couples who come to you and are seeking a divorce. So at this time, I'd like to open it up for discussion, as well as any questions that anybody might have.
Hold on. Hey, Stephanie.
Hi, Maria.
I'm trying to see if I can get my camera now opened. At least I got my my volume finally. Okay, here it is. There we go. Hello.
Hello.
Excellent program as always. Very, very informative. I have a couple questions. One is on the 3-year delay on the entry of the final judgment in a divorce. Do you have any opinion whether it makes a difference who is the petitioner? Does it matter? Do you think that the 3-year stay triggers regardless of whether the alleged incapacitated is the petitioner or whether the, let's say, the healthy spouse is the petitioner?
I'm glad you're asking that question because I've had both situations in the last few years in guardianship cases that I've handled. So it's applied by the probate judges regardless of whether the petitioning spouse is the one who's been declared incapacitated or they're the competent spouse.
So they don't see any difference at all?
No.
Have you learned about kind of like an inconsistent application of that in different circuits between, in particular Dade and Broward, because I don't practice in Palm Beach?
No, I can't say that I have.
Okay. I know I can tell you, I can share with you that there will be, I think, a subcommittee created in the legislation committee of the family law section that's going to go looking into that as to whether there's a basis to keep that still in place. That statute's been around for a very, very long period of time. And what was the intent, and is that intent still necessary, and et cetera, et cetera. So I'll keep you posted if anything develops. Their meeting is in June. So
Okay.
if you create a committee to look into that statute and whether it should be amended or not, I'll let you know.
I appreciate that because I think there probably needs to be some collaboration between the family law division, the elder law section, and the reptile section.
Yeah, absolutely. I have another question regarding the Senate Bill 226 for the support for dependent adult children. It hasn't been signed by the governor. I don't think it's been provided to the governor yet, and he has 15 days after he gets it to sign it. If he does nothing, it becomes law July 1st. One of those provisions is, it leaves it kind of up in the air as to where the jurisdiction will lie other than the determination of the support for the adult dependent, I keep saying it, adult children, dependent adult children, is going to be in probate court or family court because they're both circuit courts.
Correct.
So do you have any opinion there? Where do you think it should end up?
You know, I've worked on these issues in both divisions. When we're going before the family law court, it's just a matter of educating the judge. That's all. You know, they just need to understand what kind of disability or special needs we're dealing with this young adult dependent child. Is the child currently either receiving or applying for SSI or Medicaid? You know, and we go through giving the federal law, giving the state law, so the judge can follow in a memorandum.
It really doesn't. Yeah, it really doesn't matter where it ends up because both judges in circuit court, either one is competent to address it.
I think they're both competent. The only thing I would add is something I mentioned earlier, which is it's very important to have the right language in your order of support. because in the ideal world, we need that language to direct whoever's being ordered to pay the child support to pay it to the trustee of the special needs trust or
Right.
pool trust.
Right.
That's what needs to happen. We really don't want it going through SED, and then it goes to the parent that has, primary custody of the child. That starts getting messy, and my ability to explain that to a government agency isn't going to go very far.
Right.
But if we put that magical language in the order, that's golden.
Right. That's a very good point. I think what will happen ultimately is if it becomes law July 1st, I suspect there will be some sort of administrative orders coming out of the circuits from the chief judge, dictating or assigning those particular cases as they come in. If they had a predecessor family component before the 18 years of age, maybe it stays there. But if there was nothing, addressed in family court, maybe it goes into probate court. But it's going to be interesting to see what administrative orders come out, because I'm sure there will be some.
Well, keep me apprised, please.
You may be telling us. You may be learning about it first. But if I get any intel, I will absolutely share it with you.
Thank you. Thank you.
Thank you.
Tana, I see you unmuted your mic. Did you have something you wanted to ask or add?
I had a question. First of all, I was wondering if you could just go a little bit further into when it is appropriate to have an individual designated as a guardian advocate for a young person or a young person with developmental delays or special needs.
Okay, thank you for asking the question. So under the statute and the clerk's office, they will not let us file until the day after that child becomes age 18. But what I do recommend to parents is let's start exploring these options of guardianship versus guardian advocate 4 to 6 months before your child's 18th birthday. It gives them time to really think through, do I want to be removing legal rights? Do I want to leave those rights intact? What am I trying to achieve here? And then once the client has chosen whether we're using the guardianship process or the guardian advocate process, we can get all the pleadings ready. They have to have some time because they do have to be fingerprinted. There is no exception made for fingerprinting.
What if you're dealing with a situation where parents are already divorced, the child is beyond 18, and the parents are now elderly? And it's a beyond a family law issue now, it's an estate planning issue, I think, and thinking of the needs of your child who's not capable of, really 100% fending for themselves in the world.
Yes.
Should parents in that position, even if the child is still functioning independently and is, doing well, knowing that they won't be here forever, would you recommend that those parents look into, as part of their planning for the future when they're no longer alive, of appointing a guardian advocate for their disabled child or developmentally delayed child, before they're no longer here?
I would. But here's where the division in thought process is. Most times when I see that the parents are of advanced age and they haven't done either a guardianship or a guardian advocate, it's because they're coming from a generation where you didn't talk about that your child had a disability. Whereas in recent generations, and thanks to the internet, there is so much information and support out there. There's support groups if your child has autism, if your child has Down syndrome, if your child has cerebral palsy. So it's much more accepted socially to talk about it, to get help. And so I see with younger generations, they're being told about this in school. They're being told this at the doctor's office. And so they're pursuing it in their child's 17th year. Whereas like this week, I did get a phone call from an adult daughter whose mother just passed. Her father is no longer capable of taking care of her brother who has a developmental disability. And the parents never pursued either guardian advocate or guardianship. So now we're starting that.
So that sibling in that instance, are they forced to pursue a guardianship rather than just being a guardian advocate?
No, No, so it has nothing tied to the age. It's just we can't file before age 18. But
I
it
see.
doesn't matter. I've had people in their 50s and 60s when the parents are passing away and we're doing the guardian advocate for the first time.
Can I ask one other question related to the
Sure.
same issue
Yes.
about the special needs trust? If I understand you correctly, if parents in a dissolution of marriage action have a child that needs that would benefit from a special needs trust, if child support is uh, paid beyond 18, you're stating that the child support should be directed into the special needs trust, not into the former spouse's hands beyond
Exactly.
18, correct? And
Exactly.
then for that trust, if the person with special needs is not capable of having the money distributed directly to them as the beneficiary because they can't manage a financial account, they can't read, and then so a sibling or a trusted family member has to stand in their place as the beneficiary. Does there need to be an entirely separate person identified as the trustee to manage the trust? And
Okay, no, great question. Very practical. And thank you, because I didn't really go into this during the presentation. The key under the SSI program and the Medicaid program rules is the trustee is to never pass money through the hands of the trust beneficiary, because then it counts. So we tell the trustee, hey, this family member might be a guardian, might be a guardian advocate, maybe, power of attorney, who knows? They're the one that's going to communicate with you on behalf of the beneficiary. They're going to tell you what the beneficiary needs. They're going to send you estimates. You, Mr. Trustee, are going to pay the vendor directly. Whoever that is
pay
that you're,
who directly?
the
The
vendor,
vendor.
whoever's providing the product or the service is who we're going to pay. So it never passes through the hands of the trust beneficiary, and we never run afoul of any of the government agency rules.
Okay, that makes sense to me. Thank you.
You're welcome. All great questions. And as I mentioned earlier, probably in 24 to 48 hours, we will have the recording and we'll be happy to send it to all of you. So if you want to listen to it again, you want to share it with a colleague, somebody you feel could benefit from it, I'm happy to do that. I want to wish everybody a very safe but a fun holiday weekend coming up. Thank you for taking time during your lunch to listen, to ask great questions, and I look forward to working with you and seeing you on another webinar.